Shall we start?
So we are just waiting for some more students to join. Just six that they'll be joining in like 2 3 minutes.
Just let me know. Be a good time
Yes.
to start.
Hi, good evening, guys, to the last session of Benchmark Chapter 1. Today we have Dean of GT Goenka University, Dr. Deevanshu Shrivastava, sir, who would be taking a lecture on how to write a research paper. I hope this session will be great for you. Thank you so much, Deevanshu, sir, for accepting our offer to come and spare out some time with students. And just a pre-announcement, as I have already informed via mail, that you guys gonna have a big bash and a good offer coming in. So there's a special thing that we have planned for you all. So please stay tuned till the end, as today is the last day of our benchmark chapter 1. There is something special coming out for you guys. Thank you so much, sir. I think it's a good time we can start off.
Yeah. Thank you so much, Varun. Thank you so much, Path, for extending that invite for me. And I know it's your first chapter, but I'm also pretty confident that many more chapters of this wonderful exercise that people have undertaken is on the cards. And as Varun has already made the participants a bit enthusiastic about that, what lies at the end of this particular session, I really hope he has not taken my session's charm away. Um, but I'll come to a very honest thing that when they were planning this, the session of how the first chapter would be unveiled, um, and the topic that was given to me is something which is very close to me. The reason, I guess, is something I guess Path can compliment for that as well. That how research is not only a thing that it is just like something that shapes up with the passage of time. It is immediately like what it was my first research paper to what mistakes I've written or what mistakes I've done in that particular thing, to a journey which is endless, which is never accomplished. If I say, like, at this stage of my life where there are so many scopers, there are so many UGC care publications for me, and I've achieved everything, I guess it is always like I've just taken the first step towards achieving or towards that mountain trail that I have in front of me. And it is endless. So I would start off with a wonderful thing that has helped me to start my research career, both and it started as a student, and also how the concepts of researching in the student era to one when we enter our professional space to even many of you might be having this aim to join a law firm or an office of a general counsel or even as an independent litigation. Research goes hand in hand. uh, Major of you who are also inclined towards the judiciary exams of various states, believe me, research still goes as how well you might have seen, and you generally get fascinated about a usage of a Sanskrit shloka in a judgment, how that particular thing is linked to the particular judgment or a paraphrase or the paragraph of that particular thing, or how the paraphrasing of a judgment with the legal point based on the particular facts are inclined towards examples in the form of what shlokas and um, other learnings from various things to take it. To start off this session, by the time I'm sharing the presentation, um, I generally believe that you'll have to be a good reader to be a good writer. And that is how we generally take. Um, the topic also that I'm taking today is in relation to that how this legal process takes place. And when I talk of legal research process, each legal paper is nothing but a combination of how we are researching over the same. So during this next course of 50 odd minutes that is being allocated to me, um, I would take it to a journey and invite each one of you that this doesn't requires any, so we can come out with our open slates. We can come out with an open parameters that yes, there is nothing called as a rocket science of what, how, and how to write a legal research paper. Yes, it is a combination of many steps which are inclined, which are linked to each other and which are also interlinked towards what may be your output. So with that, to start, I'll say that to define the legal research, research itself is a term which is not, and I'll break that myth at the starting itself. Research never means to research or something. And with various other definitions available for research, uh, legal research is one of the domains of a research where anything that we are planning to search on to must require a legal angle. This can be that an historical way of how the law is evolving, or this can even take us that how the law has been and how it needs to be changed or altered, and even how a present law is no more required by the society. And for that thing, I'll quickly ask you people to jump towards the definition of amendment that is provided under the Constitution of India. Now, as you people are aware, and even if you're not, please read it as per what the 368 provides to us. And it provides very clearly three basic terms. And if I may ask anyone who wishes to answer that, can unmute, and I'm giving you 15 seconds if anyone who wishes to volunteer for me that the amendment word that is used or the amendment definition as per the Constitution includes what all three things. I hope they have a right to unmute themselves.
Yes, sir, they have. Yes.
Okay. So I'll just wait for 10 seconds. If somebody volunteers, that's perfectly fine. Else, I'll help you to take it ahead. Okay. So I hope nobody is willing to take it up. So,
May I?
yes, please.
I think amendment is an article which is given under Constitution under Article 368, in which you can change, modify, or add or remove some words or by updating the parts of the document or the document like as such Constitution.
Okay. So, okay, perfect. So you said four terms: change, addition, variation, and removal, correct?
Right.
Okay. So if can I please get your name?
Sweksha.
Sweksha. So Sweksha, what made you say ki Because if I'm adding something to a legal document, so would that be like addition is under the definition of change itself?
Uh, I think partly yes, but partly no.
Okay.
Because partly yes, because अगर आप कुछ add कर रहे हो उसमें, for
Okay.
example, like first time preamble amend हुआ था and socialist, secular and integrity word add हुआ था by 42nd Constitutional Amendment Act. तो बेसिकली उसमें मॉडिफाई मतलब वो चेंज हुआ था बिकॉज ऑफ द रीजन वो प्रियम्बल उसमें 3 वर्ड्स ऐड हो गए तो दैट चेंजेस्ट बट नाउ सेकंड पार्ट इज लाइक पार्टली नो बिकॉज आप मॉडिफाई भी कर सकते हो ना लाइक आपने वर्ड डाला तो वो चेंज हुआ बट फॉर एग्जाम्पल आपने लाइक इंटरनल डिस्टर्बेंस को हटा दिया था 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट से सो इंटरनल डिस्टर्बेंस हट गया था उस समय तो उसके बदले आम उसके एक्सचेंज
शिक्षा
में
कहाँ से
लाइक
हटा था इंटरनल डिस्टर्बेंस?
लाइक फ्रॉम इमरजेंसी पार्ट
परफेक्ट, ठीक है। तो व्हेन वी वर स्टडिंग 352 तो इंटरनल डिस्टर्बेंस
हाँ
हटाया इन्होंने और क्या ऐड कर दिया उसकी जगह?
आर्म्ड रिबेलियन
ठीक है। तो डू यू कंसिडर इट टू बी एन एडिशन और यू कंसिडर इट टू बी अ चेंज?
अ चेंज नॉट इन एडिशन
So,
एडिशन
I'll
प्रियम्बल में हुआ
perfect, perfect. So I'll just come back to my question. So my question was very clear that if we add something, does that contributes to change?
yes I think you are changing enough
Okay, yeah, perfect. So it is not a perfect answer which has a partly yes and a partly no. It would anything that we add would automatically change that particular thing. And this goes true for ourselves as well. So for example, if I have a pencil box which has 3 pens to it and I'll add the 4th one, this will automatically become a change, correct?
right
Yeah. So the words that are used, thank you so much, Swiksha, for that. And the words that are used for amendment is addition, variation, and removal. I'll come to that word that Swiksha also pointed out the last R terminology, which is removal. Under law, we do not go for removals. We go for repeals. Now, there is a difference between removal and repeal. Removal from a particular perspective is always how it has been taken away. Like she rightly mentioned in the case of when there was an amendment by the 44th Amendment under the 352 article, and internal disturbance was removed and the word was added. Always remember when the words are being interchanged, when the words are being like one word is added and the other one is removed, it is also called it will also be called as removal. But for the wider interpretation, repeal of the acts are also considered to be amendments. And this exactly is what makes us understand that when a terminology like amendment comes into an act, whether it's the Constitution of India or any other legal act that we see, we will be abide by the 3 rules that is given out. There are 3 words that is always happening. Similarly, when I come to a concrete definition, I guess there can be many. Each philosopher, each legal thinker has pointed out for many definitions. But one definition that I personally follow, and I personally have been listing it now nearly for more than uh, 15 years, is and do see this definition. This definition sees research as something that helps you to know the unknown through the known. I'll repeat. Research is something that helps you to know about the unknown through the known. Now, if I ask, and if I open this forum as well, and I'll quickly ask, what do you understand by research? Or what is the purpose of research? I will get quick answers like it is something to get a new thing, something that I don't know and I get to know it. But this definition itself confines all those things together. So when I get to know something which is unknown, this is just like I have discovered that particular fact. This may also include that, okay, as an inventor, and I'm talking in terms of intellectual property rights as well right now, that as a patentee, if I am inventing something and I'm applying to get a patent over it, that was also for me a new thing. And this all definition of research is nothing but a systematic investigation. Now, when I was delivering this lecture and I use this terminology that research is nothing but a systematic investigation, I was countered by my PhD scholars, and when they said, "Sir, uh, investigation, according to me, is a scientific process and fields like law, which is considered to be social sciences, investigation do not play a role." And then I asked them, why are we not seeing? And this is prior to the BNSS coming into force. I said, okay, then have we ever seen what CRPC talks about? And if I'll quickly help you up as law students, and those of my friends who are really interested towards criminal law, CRPC talks majorly of IIT. IIT stands for, not the engineering one. IIT stands for Inquiry, Investigation, and Trial. And this is what was CRPC made up of. Um, and sorry, during the course of this presentation, I'll take this liberty of mentioning certain books. And this comes with each domain of it that, like, for example, now we are talking about the criminal law aspect. Um, I would recommend, and do not get worried over the fact that, okay, sir, you are recommending us a book which is more of CRPC and not of BNSS. Would that still be helping up? Yes, it will be. So here I'm reflecting to Kelkar on CRPC. Now, Kelkar on CRPC are two books. One is a voluminous book which contains the entire of the CRPC in that particular way. The second, and which I would personally recommend each one of you to read it, and read it as a novel. I am unsure whether you have read CRPC in your classrooms or not, but when you read CRPC from the student edition of Kelkar, read it as a novel. And the purpose I'm telling you, read it as a novel, that when we read a novel, we are engrossed in particular non-fiction side of that particular thing. Exactly. Then how the student edition of Kelkar is in the format of IIT. It is not in the format of section 1, 2, 3, 4, so on and so forth. No. And that is not a way to read CRPC. If that book you have, that's wonderful. If you are not having it, your library must be having it. If not, at least buy that book and read it. I know major of you would be having your winter breaks right now. And then please have a view on that particular thing, whether this book has changed your perspective of learning or understanding CRPC on it. And then I say investigation, and why legal research is called as a systematic investigation, because it is a methodical process for exploring legal principles, rules, and precedents relevant to a specific legal issue. Today in India, there isn't any point which would not have a legal rule behind it. Now, when I use a term legal rule behind it, you can come and say, sir, for example, AI in India is still not regulated. I would agree on that particular point that it is not regulated by a legitimized, principled act or a bill over the same. But AI in India is still regulated. There has been a whole new debate whether something created by AI, can the machine that has created that particular content, can that machine be able to claim or be exercised as a copyright holder? And yes, Indian cases have been there on that point. Can he, it was and you want to read on that particular thing, read Dabas. Read the Indian version of how Dabas case has been interpreted and how co-authorship has been given onto. But yes, in the absence of law, it is either the legal principles or the rules or the precedents which are taking up to. I'll give you two examples. First is Vishakha versus State of Rajasthan, which I guess each one of us in our law schools have always seen it. So, anyone quickly who can say that what was Vishakha versus State of Rajasthan? I would request, I will be unable to, okay, just allow me a second, I'll join it parallelly. So I can access the, okay. Anyone else who can unmute and let me know what is Vishakha versus State of Rajasthan?
Yes, sir. Vishaka was a state of Rajasthan, which was a Supreme Court judgment given in 1997. It laid down the guidelines for sexual harassment at workplace, like what has to be followed if there are any sexual harassment cases which are happening in the workplace because of an aggrieved woman who was gang raped by five men while
Okay.
she was in the work while she was working.
Well said, Fenil. So, Fenil, who was Vishaka?
Vishaka was the NGO,
Perfect.
the name of the NGO, and yeah,
Which filed the PIL in that particular case. Perfect. So
yes,
now, Vishaka, and let me be very clear when I say this particular fact, we all know there are three wings: legislature, executive, and the judiciary. Judiciary never makes a law. Now, if what Fennel described it for us, can we say that this is a perspective where judiciary attempted to make a law? Yes or no? You can now use the chat box as I can parallelly see your messages as well now. So under Vishaka versus State of Rajasthan, so Sweksha says a yes. Um, Couple of seconds more if you want to answer. Navya says yes. Okay, so I'll tell you, judiciary never made a law, and that is what I'm letting you understand, that we all know the separation of power theory in our country, and the precedential value of the judgments of the Supreme Court. In state of Vishaka versus State of Rajasthan, in DK Basu versus Union of India, um, Charles, I'll just come to that on the precedent side of it. But first, let me make you understand that when it is a guideline sort of a thing. So, as I was mentioning, in the case of Vishaka, in case of DK Basu, in the case of Aruna Shanbag versus Union of India, all the three judgments are best examples where Supreme Court has given guidelines. And these guidelines are followed like a law. But if you read the judgments, the paras have clearly stated where judiciary has said this is the duty of the legislature to enact a law. But this is a very expedient time where the law needs to be there. Till the time the legislature is enacting a law over the same, these guidelines shall be followed with an immediate effect. Okay. And what time did it took? The Vishaka's judgment is 1997. We see a Prevention of Sexual Harassment at Workplace Act in 2013. Nearly 16 years. But today, if I'll say that Vishaka guidelines are being followed, I'll be wrong. Why? Because the POSH Act has been followed. One can even argue, sir, POSH Act is nothing but the replica of the Vishaka guidelines. Yes, but now POSH Act itself is an answer that these guidelines are curated as a form of an act in our country. Now, coming to Charles' thing that how would precedents be considered as law by judiciary? The answer is, where are these laws getting followed? And read Supreme Court again. Supreme Court, whenever it lays down any judgment, like for example, today we study Bachan Singh versus State of Punjab, and it talks about rarest of the rare case. What is that? That's a doctrine that has been incorporated for the courts to follow it. Precedents or landmark judgments that have been followed are having a precedential value over and what the facts remains the same as well. And this exactly would be considered as the rule making power or the precedential value of the judgments that the higher court has over the lower courts. So when I talk about a legal research, it is about, as a legal researchers, each one of us needs to explore a legal principle or a legal rule or a precedent which is relevant to a specific legal issue. Now, for example, if Sweksha is there and Fennel is there, and I'm giving you a topic that death penalty in India shall be abolished. Sweksha took a topic A for the favor of the motion, and Fennel took it against the motion. That Sweksha thinks that yes, in India, death penalty should be abolished as it's a grave violation of the human rights. On the other hand, Fennel believes that yes, no, it should not be removed, and it has been taken as a rarest of the rare case doctrine, not in all the cases, but few cases do require, and the person to whom it is being awarded is no more a human. Therefore, no human rights should be exist on that point. The topic remains the same, but the legal research in a very methodical process remains different for Fennel and for Swiksha. And this is the specific legal issue remains the same for all of us, death penalty and whether it should be abolished or not. But how we are researching over the same, that method may be different for each one of us. From there, when I move towards the importance of the legal research, you'll understand that it forms the foundation of a sound legal arguments, accurate advice, effective representation, and the informed judicial decisions. This is for all of my friends who, and if somebody asks you how to study a case law, I'll tell you this one small 2.5 liner thing defines that how you should study a case law. Not only that, if I'm asking you today that through a legal research, I'm asking any one of you. So you remember the example that I just gave where I put Swaksha and Fennel at two different junctures, and I said death penalty should be abolished in India. And now I'm converting that thing into a case comment. So now the case comment title reads a case analysis or a critical analysis of the judgment of Bachan Singh versus State of Punjab. And similar volunteers for me, Swaksha writes that the analysis done by the Supreme Court and coming out with a doctrine of rarest of the rare case is something which is a part of it, but it should be abolished and the maximum punishment shall be a life imprisonment, because we believe on the Gandhian principle that the jails or the prisons are made for the reformation of a thing. It also comes with a judgment that cites that every saint has a past and every sinner has a future, and one person shall be given a right to reform or to address that he has made a mistake on that point. But when you write a case comment, this is how your things should be taken. Number one, the foundation of a sound legal argument from both the sides, never from one side. Second, when you're writing a case comment, be very on an unbiased approach. नहीं मेरे हिसाब से death penalty तो हटा ही नहीं चाहिए. If you start off with this mindset and then start writing, you'll always be on a side of it that death penalty should be abolished. As a legal researcher, whenever you are doing it, whenever you read both the arguments from both the sides, which is there as a part of a judgment, read it. Accurate advice is what the lawyers generally advance of their thing. This is also something that would help you in mooting as well. And the other day when you were having this class on mooting, this was one of all particular things that you need to advance what the particular arguments are. Third, effective representation should be there. And lastly is the informed judicial decisions. And I'm coming back to Charles, what he wrote for the statement is that how precedent on and what is the law of the court on that particular point itself, whether the court has decided that thing in the past or not. We recently saw where we had the previous Chief Justice that how right to privacy thing was advancing from 20-25 years to what today when we saw it. It was also a judgment, a landmark judgment, but that landmark judgment was taken away. So with that, I defined that what is a legal research and what is the importance of a legal research to take it up. Moving ahead is the best way. If I today ask what is a method, I generally follow this IRAC method. And IRAC method stands for I stands for issue, R stands for rule, A stands for application, and C stands for conclusion. So if we as law students need to identify a issue of something that we are going to take it up, I would take it with a perspective of issue, that what is the issue behind it. Like for example, if I'll give you a civil law example, a contract example between two people, A and B. It was, for example, the contract for buying of this particular pen. And when this particular pen was being bought, it was agreed that the price of this pen would be 10 rupees. And I want such 10 pens for myself as what B said to A. They agreed that, okay, the delivery shall be once the pen would be delivered, you give 100 rupees to me for all those 10 pens. It was agreed. What happened that out of the 10 red pens, 9 was a red pen and 1 was a blue ink pen, which was not accepted by B. So when we come to that particular issue, we see that this has a varied component, and in that case, B paid an amount of 90 rupees as to what it was agreed for them. Now, if I'll ask you what is the legal issue behind it, you may quickly answer me that there are two legal issues. Number one, that the pens that were asked were not appropriately delivered. First issue. Second, the payment was made on a pro rata basis. Therefore, this is the second issue. What rule would be involved out here would be under the Indian Contract Act of 1872. Now, this is the law which I'm reflecting it here as a rule, and application of that law over the fact that we just discussed between A and B. And that is termed as your third stage of it, called as the application of it. And then finally, when we conclude it, we conclude that whatever application of the rule over the issue was can be taken in either A side or B side of it. And that is what is said to be a valid conclusion. So a structured approach to a legal analysis would always be followed with an IRAC method. And that IRAC stands for issue, rule, application, and conclusion. Charles, I have read the statement that you have mentioned in the chat box. I guess in the coming slides, I'll try to answer that in that way. Now, but before I move ahead, I'll just answer it in one particular line to you. What is a weak law and what is a strong law would always depend on the factual conditions, and it depends on case to case thing. And I'll come to you on that particular thing, that how are the hierarchical method mentioned that understands or make a particular thing to be a strong thing or a weak law on that particular point. So when we have adopted the IRAC method, the first and the foremost thing that we have to do after that is to use the W5H method. And this W5H method is who, what, when, where, why, and how. And as a law student, I would always suggest you, please ask these questions, specifically when you're going for a mooting, specifically when you're writing a legal research paper, or even when a question has been asked in your question paper. If you are able to answer the W5H questions, even if it is not asked to you, and frame that in your particular answer, you would be 80% correct on all the things that has been asked. You can take that, for example, if I'll ask you today, shall AI generated, I'll come back to the same example, shall AI generated work should be allowed copyright in India? And then let's break this W5H in this particular thing. So who, it's an AI generated machine or an the LLM model that we generally call, not the LLM that we pursue after our LLP, but the LLM is the large language module thing. So who, that is the machine on that particular point. Second comes what. So what this AI machine has generated, a work which is considered to be original by nature. When, under what situation this particular work was brought, whether the applicability of the Indian Copyright Act of 1957 was there or not. Where are we bringing that matter? This is the territory, the under the periphery of the territory of India. Why is that a question? Because under the law, copyright provides that an author needs to be a person, and AI do not fall under the ambit of a person. And then how that shall be taken. So we see a precedent in India that the robot was allowed as a co-author for a particular thing. So look, when I divided any topic, and for that matter, if you want to suggest any topic, please use the chat box. I can explain you this itself, that how this W5H model would always be helpful, specifically if it's a legal research that you're going to carry out. And this not only helps you to gather the relevant facts, but also the potential legal claims. And that is where I have told you the issue, the rule, and the application of it. So once you are taking it up, Shiksha, issue as in what is like you want to know what do you understand by issue?
No, actually, I'm giving an topic basically. Should reservation be allowed in India?
Perfect. Now, if this is a topic, should reservation be allowed in India? Reservation is already allowed in India. Your question should be this
No,
way: that should reservation
continuously.
be, huh?
Right. Should reservation is continuously allowed in India? Like it was not continuously allowed at starting.
It is, again, I'll tell you. We all know reservation was not an original part of our Indian constitution, correct?
Right.
Yeah. So it was incorporated. The Mandal Commission thing comes into play. There was an amendment made and everything. And read the reservation thing. It is a temporary provision for 30 years, which is now increased for 10 years only. So we all know as law students, and this is again my urge to you all. I know you have your personal biases over the same ki nahi sir, reservation sir should not be there, and we as general we have suffered this particular thing. No. Always remember, whenever we see reservation, reservation is a concept of right to equality. And I'll make you understand this in a way. Income Tax Act provides for slabs that if you earn more in your country, you'll pay higher the tax. If you earn less, you'll pay lesser the tax. This concept of income tax, and it was challenged as well, that this is violative of right to equality. But the answer is that it is not violative of right to equality. Why? Because the concept of equality is bringing, and it's absolutely on the concept of what we see under the law as the intelligible differentia, the doctrine of how the, thank you, Fenil, for that. So the racial nexus and the intelligible differentia that we are taking on to, but it is also to bring equity in the society. So right to equality, when we see from Article 14 to Article 18, it incorporates in itself. So coming to Sweksha's point, now if I'm putting shall reservation be stopped in our country, so I'm just tweaking a bit, but keeping the essence what Sweksha asked. So who, what, when, where, and how? Who are we talking about here? Because reservation was incorporated by the government itself. Who can stop it? The government itself, correct? What the government needs to stop? The reservation policy in India. When are we going to send? And this when answers with two things, something that I discussed. Number one, it is a temporary process. It was earlier made for 30 years, which is now extended for 10 years. Now, you can, as a law student, can see that earlier something that incorporated for 30 years is now only brought for 10 years. So this shows the intention of the government that they want slowly and steadily, they are planning to reduce it. They could have easily put it extension for 30 years more. But that is how we are going to take that thing. Where under the government services only. So for now, in a private atmosphere, in a private company, in a private university, the concept of reservation is not at all applicable. Correct? So no law firm, when it comes, they'll say, no, I'll hire, I have 5 posts, I'll hire 2 general, 1 SC, 1 ST, and 1 OBC. No. They want 5, they can be all 5 for general, and there cannot be any case. But for example, if a civil judge post on that matter comes into play, and there are 20 seats, the rule says that 9 seats or 10 seats can be there for the general, and rest 10 seats would be divided among the SC, STs, and the OBCs. So where is that? This is the government services, and read 15. It clearly provides only with the government services. Why was reservation brought? So today, if I'll ask, and I am opening this thing again, reservation in itself, as I said about the income tax, as also rightly mentioned by Fenil out here, the concept of reservation was to bring equality in the society. So that the ones who are left behind can also have an equal thing. I'll pose the same question to you all. The Maternity Benefit Act. Under the Maternity Benefit Act, or the example that I cited was for POSH. So these two laws are made under the purveyance of what Article 15, Clause 3 under the Constitution provides. And it says, and I'll read it for you, the government can and government shall make special laws for the protection and upliftment of the women and children in our society. So maternity relief under the Maternity Relief Act can be claimed by a woman for 6 months. While on the same thing, if you'll find there is no provision related to men. Now, if you say this is violative or this is violative of right to equality of men, the answer is no. And this is what an answer is all to be taken on to. And how are we going to reduce? Because my topic is now very clear. How am I going to reduce it? So when we see these censuses happening, when we see that the education level in these particular societies have increased, slowly and steadily, there can be these amendments that we can bring into the law. Like, for example, the concept of socially and economically backward classes was used. So economically backward classes can be, okay, there wouldn't be any reservation, but for example, the civil judge form fees is 1,000 rupees. For SC, ST, the fees would be 0. So this is one way to cater but the position remains the same. But for them, because they are economically backward, there would be no examination fees for them. So this is one of the suggestions of how you are going to deal that particular thing. And then you need to identify, okay, reservation in India is being provided only to socially, educationally, and economically backward people. And that is how we are going to cater that particular. I hope this example is clear and the example that I cited as well. Any doubts so far to any one of you? Okay. With that, I'll move towards how we'll have to develop a research strategy. Now, when I'm talking about a strategy, I know each one of you today know how to search on Google. But unfortunately, on the parallel hand, I am very confident in telling you this, that you even do not know how to search on Google. Google is a machine. Google search does not follow a statement. But Google, being a binary thing, and I do not know how many of you are aware of this term called as Boolean operators. This has to be the common perspective when we studied computer sciences at our school level or at anything. Boolean means the gates that was generally talked onto. And there were basic of 3 types of gates that we see: AND gate, OR gate, NOT gate. With the combination of all the 3 majors, we can come on to NAND, NOR, and other such form of things. So NAND was not AND, NOR is not OR, the combination. And when we write AND, like for example, today I have to search AI generated work and copyright in India. So I would not use a sentence, what is the legal perspective of AI created work under the Copyright Act of India in 21st century. No, I'll use the terms AND means whichever search, then the results that come out with search, all the research, all the searches which has both of these terms, you'll get it. I'll tell you how to do that as well. When you open a Google search, and if I can request each one of you can parallelly open it. Under the search, there is an option for tools, the advanced tools, and there you can type all these words. This is how we are going to take a particular example, number 1. Number 2, this is also how major of the legal databases in our country, name it, the LexisNexis, the Thomson Reuters, the Manupatra, SCC, EBC, Reader, whatever it is, they all still follow for a search something which is called as a Boolean operators. So this is how Boolean operators work. Now, when I'm talking about the thing which I guess Charles has also taken up, so keywords usages. Now, when I'm talking about a keyword usage, you as a researcher, how did you identify a keyword? I'll come back to the slide. And when I said the issue rule and the application, the W5H model, this how and why will help you to identify the keyword that you are searching for. I'll also help you that today, when you start writing a paper, you start off with your paper with an abstract. And right after the abstract, you are always allowed to mention 5 keywords. The purpose of these keywords is that tomorrow, if you have written a paper on AI and copyright, and Devanshu sir is planning to write something on that, and I'm searching on it, the keywords that you have mentioned in your research paper would help me when I'm searching on that particular topic itself. So this helps you to refine your search of what and to lead to a particular point of where you want to reach ultimately. Second is under the legal databases. So once you learn how to search, you can utilize softwares like Westlaw, LexisNexis, Hain Online, JSTOR for leveraging the advanced search features. And please, whenever, and this is my request from each one of you, stop using just a Google search option. Click on the advanced search, which is available right below the where the Google search bar opens. Right below that, there is an advanced search option. Similarly for Manupatra, similarly for LexisNexis, similarly for Hain Online, JSTOR. These are the good things. And you remember I started off with my presentation by saying good readings would lead to you to good writings. Now, good readings itself is an answer that, okay, if I'm reading something, so today if I have to write something, I'll come straight back to my example of AI generated work and the copyright. I'll have to read what is the law, what is the various researches done by various other legal scholars across the world. So I'll take an example. I'll borrow a paper from Canada. I'll read it up. That's available on JSTOR. I'll take it something from Hain Online. I'll also, by the end of this session, I'll try to give you a couple of free legal databases as well in our country, which are wonderfully well and I guess it should be mandated for each law school and the law students to take it out. If these two doesn't work, which I guess won't, there are the free online resources that I was reflecting on too. And you can use that. For example, Google Scholar. And I do not know how many of you are totally inclined towards a research thing. Everybody should mandatorily have a Google Scholar ID. Post all the research that you are doing on Google Scholar so that it helps you to build your own profile as a legal researcher or as a normal researcher as well. Justia is there. There are other softwares that also helps you. So when you publish your papers in Scopus journals, you have to maintain a Scopus ID. There is an ORCID ID, which is very, very important. And believe me, if at this stage of your life, if at this stage of your legal researching career, as law students in your third years, in your second years, as I was told by the organizers, if this stage you are building your profile as a legal researcher, your profile would be enhanced like anything. And I'll be very honest in accepting that fact as well, that when I was a law student, unfortunately, we were not told about such things. And I started off very late. I believe it was my pre-final year, the 4th years, when I started off for my first legal research paper. And by my entire career of 5 years ended, I was more into moots, I was more into debates, but my legal research quotient reached only 2. Which, fortunately for me, when I was pursuing my LLM of 2 years, it went nearly 4 times. So the total count post my LLM was 10. And this helped me to enhance and to be prepared if I was taking academics as a career option. If I was taking PhD as an option, that post my LLM, I have to go for my PhD. And even today, when I'm pursuing or I'm on my final leg of having a postdoctorate study from US university, these things are helping me to build my profile up. When I say this, this is a recent trend of how researchers are taken into advantage both by law firms. I'll suggest you as well, and let me pose that thing for the questions that may be asked by you at the end itself. Now, once you have reached that these are the sources that you have identified, a very important, and believe me, I consider to be a cardinal rule, that it is not merely about locating the sources. Locating of the sources is Google पे type किया, enter मारा, आ गए पहले पेज. Only 5% of the people generally go beyond the third page of what the Google's answer is available for us. Only 5%. So whatever comes first, we take it as an option. So that is locating. But as a legal researcher, as a legal research scholar, you'll see I have used a term and. And this is not like I have just randomly written it up. This is an essential that locating and evaluating your source is as important as taking it together. So it is not like mere locating would serve the purpose. No, you'll have to locate and then evaluate your source. So it cannot be a blog written by somebody. Why? Because I'll again borrow that word from Charles. It may have a pursuit. It is mere an opinion. And again, as a scholar, I would help you. Once you go for your internship, you might be very clear, sir, हमें law schools में आप लोग टेक्स्ट बुक से पढ़ाते हैं. ठीक है, I'll agree. कि contract है तो you are recommending Avtar Singh, you are recommending of not that level as well, then I'm just taking Indian author's name. So it is either R.K. Bangia or we are taught with S.K. Kapoor. And to respect to all, because look, I'll tell you, when I was studying constitution, somebody suggested me J.N. Pandey. Somebody suggested me, and please don't judge me when I say that these were the books that I've already taken on to. So somebody suggested me J.N. Pandey, somebody suggested me D.K. Basu, and somebody suggested me that, okay, why are you not reading it with Shukla? But then there was someone in my room who saw me in the library for a couple of days, seeing me that I'm studying constitution and working on one particular aspect of it. A super senior of mine. Today, she is one of the excise commissioners in one of the states in India, cleared her UPSC. She took me, Devanshu, I saw you studying this. I just want to give you one thing. Ma'am, please. She took me to the reference section and showed me 3 volumes of H.M. Sirwai and said, whatever you are reading, read it from here first. And I'll give you a tip, Devanshu, today, and that tip I'm sharing with all of you today. Whenever you are reading a constitutional provision, whenever, please have this habit of reading it through the Constitutional Assembly debates, which is available in the Sirwai book. And each law school will definitely have this book. When I'm saying to asking you to emphasize on the Constitutional Assembly debates, I'm emphasizing that why this provision. And then you might have heard this is a very common parlance, and unfortunately we as law students also talk of the same कि हमारा constitution original तो है नहीं, हमने बस copy कर लिया दूसरी जगह से. I'll totally disagree and negate this statement. We haven't copied. And I'll give you an example over the same. This is not merely locating. This is evaluating. Locating, हाँ, Canada का ये provision है. South Africa का ये provision है. Government of India Act से हमने ये ले लिया. हमने ले नहीं लिया. हमने वो देखा जो हमारी इंडियन कॉन्स्टिट्यूशन के लिए जरूरी था. हमें मजा नहीं आ रहा था वर्ल्ड का लेंथीएस्ट कॉन्स्टिट्यूशन बनाने में, बट हमें ये चाहिए था. हम एक ऐसी कंट्री की बात करने जा रहे हैं, और आप सोचिए 2 years 11 months 18 days we took to make this particular wonderful piece of legislation. Hats off to the members of Constituent Assembly and hats off to them because they debated over the same. ऐसा नहीं है कि अच्छा ये इतने लोगों का ग्रुप है, एक कनाडा चले जाओ, एक यहाँ से लो, जो आपको वहां से अच्छा लगे ले आना, हम डाल दें. No. And I'll tell you and explain you this with an example. If anyone can again be a volunteer for me. Navya, are you there?
Yes, sir.
Okay, so Navya, what is your favorite color?
Black.
Very good. Do you have a car?
Yes, sir.
And which color the car is?
It's of dark blue.
Why?
That was my father's choice.
Perfect. Now, what I'm trying to let you know, Navya never bought a car. Guys, let me be very clear. She's still a student. So it is her father who bought that particular car. Okay. Now, have you ever wondered that there, and which model, Navya, if I may ask?
Sir, it's actually the latest Aura.
Aura.
Yes, sir.
Okay, perfect. So now when I say she might have gone with her father एंड शी बिलीव्स कि नहीं पापा ब्लैक खरीदनी चाहिए थी, पापा ने नहीं खरीदी, पापा ने डार्क ब्लू खरीदी क्योंकि वो पापा का फेवरेट कलर था. करेक्ट. Now, when she is on road, driving in her aura or sitting back, she might see different color of aura cars other than her own, which may be of something. Uh, it can be, I'll give you my example as well. So a car that I have is a Jimny. It's a white color Jimny that I have. And I often see a neon green color Jimny. And I say, who in the world buy this car? Okay. Or for that example, my favorite actor is X. I saw in a movie X was wearing a leather jacket. I went to the mall the other day. I saw, oh, this is the same jacket which my favorite actor was wearing. I tried that particular jacket and it was not suiting on me. I did not bought it. Thick. Now, if I wore that jacket, I saw myself in the mirror and thought, okay, this is wonderfully working on me. I'll buy that. Would that be said that I copied that particular X actor? The answer is no. Will, in Navya's case, we can say that Navya copied X person in buying Aura car of dark blue color? The answer is no. Why? Because she, after 5 or 6 cars, she found one car and then she and her family members decided, evaluated that when we are going to buy this particular car, will this suit, and evaluated the conditions of their adjustment with a particular model of the car, including the color. And I'll just keep this thing open. Whenever we sit inside the car, unfortunately, we are unable to see the color of the car. And this particular thing is similar. So Indian constitution is not a copied constitution, number one. Indian constitution is not a borrowed constitution also. Why? Because when we brought concepts of other countries, these concepts was brought under the lens, debated, and then some kept as it is, some were changed. The best example, excuse me, Article 19(1)(a). We got the freedom of speech from US Constitution. But none of the constitution in the world had the concept of expression with it. So the Indian right, the freedom that we have in under 19(1)(a) talks of right of freedom of speech and expression. It's not merely speech. So they debated, they said, nahi, speech keval nahi, what about the expressions of our people, which can be in the form of drawings, which can be in the form of cartoon characters. And imagine, today the expression that we do on our social medias through emojis is also constituted under the similar expression that I'm reflecting on. So the choices of words in 1947 till 1949, 2 years, 11 months, 18 days, is exactly which today covers major of how the expansion can also happen. And this is termed as evaluating the source. And this is very, very, very important. So shepherdizing or key citing is something that I was reflecting on to, followed by a critical evaluation of what all sources that I have taken on to. This includes the access to the authority, reliability of the source. So as I was giving this example, we teach with the textbooks in the in the classrooms. Have you ever seen a textbook being cited in the court of law? The answer is no. Exclude Sirvai right now. Again, Sirvai is only cited because they have to bring a constitutional assembly debate, and for constitution, Sirvai has been cited so many times under the Supreme Court judgments and many. But you won't cite J.N. Pandey. Or tomorrow, for example, Deevanshu sir writes a book on IPR. The book would be a textbook and it won't be cited. Similarly is with the newspaper editorials. They do not have a value out there. And the reason is because it is somebody's opinion. You might have seen nowadays newspapers under the article write that this is the personal opinion of the author. The newspaper is not bound with the same. This is also the reason why now when you search on AI tools like ChatGPT or Gemini or any such thing, there is a clause that please verify the statement before using or before citing that particular. So what and whom it depends upon the author's credentials and the reputation of the publication. And this is what is termed as mere locating won't be an answer. You'll have to evaluate before you proceed for your own research. Now, once that is done, we would take it to an answer of how the organization or the analyzing of a particular information that you have gathered would be taken. So take a note of it. Take a note of whatever you have gathered. Use a consistent format such as an outline or the mind map to record key facts, legal rules, citations accurately. Now, for a law student, believe me, whether you are making a brief for the court, as in when you are interning with a advocate or a general counsel or even law firms, you'll have to go in a chronological order. And I'll come to this thing, even when you go for your interns. Have you ever seen a law file or a case file that is being produced in the court of law? ऊपर dates लिखे होते हैं. And it is always kept in a reverse order. कि जो सबसे पहला वाला इंसिडेंट होता है वो सबसे नीचे. A good file looks like this only. And then how the chronology has developed, you keep on keeping the pages. This means the latest development is always at the top. And then you can tag it up. This is exactly a way a legal research scholar should work. Whether it is you are writing a small abstract, whether even you are writing an answer for your mid semesters or your end semesters, chronology, these things are habits. And once you are developing this during the course of 5 years, 10 semesters, you are developing this habit of even writing an answers. This is exactly a habit that you are developing yourself wherever you wish to join yourself as a again, as an independent lawyer, as a general counsel, as a law firm member, or as even for the judiciary. Also, which is very important, and one line that I'll always borrow from CPC is Order 6. If you have studied CPC, fine enough. If you haven't, Order 6 talks about Order 6 talks about pleadings. Order 7 talks about plaint. Order 8 talks about how written statements and all those things have been taken on to. There, it is always said the plaint needs to be paragraphed. The plaint needs to be point-wise. The plaint needs to be precise. And that's exactly when I use the term organize. How, if I tell you, and I guess this is one thing you people might have heard, even if you're living in a hostel nowadays, or you're living with your parents, the first and foremost thing your parents have generally asked you is to organize your room. I generally feel that that's the thing that you've always heard. Organize your room or organize your table. I had this habit even prior to my law school days. And even today, if I'll invite any one of you to come to my room, you will find that my room is an organized one. And I come to know this fact that somebody has entered my room because the things are not at the right place. All the files are generally kept in an alphabetical order. Now, this is organizing because this helps me. And this is exactly what I'm trying to let you know. Organization doesn't comes with a particular separated formula. कि सर ये formula है और ऐसे ही सबको. Organization or organizing something is a person specific thing. So Fennel might keep it in any other order. I would keep it in any other order. But the organizing skills of Fennel would be that Fennel in any circumstance can take that particular file or can locate that particular thing. This is again coming back to the example where I said that Sweksha was speaking on the same topic for the motion. Fennel was speaking against the motion. The organizing skills of, or the organizational skills of Sweksha would be different. Excuse me, to what would be the organizational skills of Fennel. The outcome, the research paper, the presentation, whatever it may be the case, it is always organized on that particular thing. And how did the organizing thing happen? by analyzing of what all we have gathered abhi tak. So abhi tak we gathered the sources from where we took all our things, and now is the time where I'm framing it. I'll give you an example which I guess we all have seen in our daily life. This is just like buying ingredients. So when we buy ingredients, it is all kept out here, and we have still not start making a particular food. So, if, for example, like today evening, I want to cook a pizza at my place. And what would be these ingredients that I need to have? I need to have a pizza base. I need to have sauce. I need to have cheese. I need to have capsicum, onions, tomatoes, olives, jalapenos, and what all I want on my pizza. So these are the ingredients which I've ordered from Blinkit. It has been delivered. It's kept right at my platform of my kitchen. This is organizing. Now, how and what needs to be done ahead is what all I have gathered. I need to analyze that particular information. Parth is here right now, and he would again agree to me. So my basic examples would always be a food example, because this is something I do not know how many of you are hungry at this time of the day, but this generally makes us understand how our research and other things would be going ahead. Now, a very last thing, once we have gathered the ingredients, we have started organizing it, we have analyzed it. Okay, ये वाला chapter 2 में जाएगा, ये वाला para 3 में जाएगा, ये वाला conclusion में आएगा. Then comes the first thing of your drafting. This is just like you have bought the cement, you have got the things. Now, as per the blueprint the architect has made, you'll start making the building itself. So, first and foremost, it needs to be a clear and a concise writing. What is clear writing? Whatever you are writing should be, number one, usage of the plain language. Number two, it should avoid jargons. Number three, that it needs to be someone not for what Charles wants to write, not what Sweksha wants to write, not what Navya wants to write, not what Fenil wants to write, not what Devanshu wants to write. Why? Because you are not writing that research paper. You are not doing that legal research for your own self. You are doing it so that it can be submitted to someone who always believe knows nothing about it. Fine. This is also when I ask you people to write your answers. I'm not worried of your grades right now, but I'm just worried that if I am inculcating a habit of a good legal researcher, that should be reflected, and you get 10 semesters, 6 papers each, nearly 60 papers, to make this habit into a perfection that, okay, I'll write it in the plainest of the language that someone who is evaluating my paper knows nothing about it, and I'm the first person who would let through her or through his answer make that person understand. At no point I'm saying that your teacher knows nothing. No. My only thing here is that as a legal researcher, whatever you are using with the clear languages, it should be free of ambiguity. It should be free from any further interpretations. And I'll tell you why. Because it would be your legal paper, the research paper that would travel. Not you would be accompanying that with that paper. Ki, sir, I wanted to say this thing, but this is what I meant by writing this particular word. No, you will not given that opportunity again. So as when you are drafting it, use the plain languages, avoid jargons, and structure the paper. And this is where the concise writing comes, logically, with clear headings and subheadings. I'll tell you the basic difference between writing an essay and writing a research paper. Essay doesn't comes with a subheading. So if I put it in a mathematical way, a legal research paper minus subheadings is an legal essay. And this is where, because when we, but in spite of the subheadings, the paragraph or the structure of the legal essay and a legal research paper is exactly the same. So you start off with an introduction, you start off by definition, you then proceed of what is the analysis between the same, and then finally the conclusion side of it. Second and very important thing, Always use a proper citation format, and please have this habit of citation or mentioning the resources there. So in the entire thing, there are various methods. So for a law student, if you're writing some international papers based out of like with a US form of study, always use Oscola. If that's an Oxford style of doing that. If it is an international, again, you can even use a blue book. So blue book, which edition is there, that is something generally comes on to many of the good papers or certain things, they prescribe as a desired format already. वो पहले से बता देते हैं कि आपको बुक ब्लू बुक की 21st एडिशन यूज करनी है या आपको ऑस्कोला यूज करनी है. ये इंटरनेशनल स्टैंडर्ड्स हो गए लीगल पेपर्स लिखने के. When I'm coming to the Indian standards, the best that is followed is an ILI format. ILI is the Indian Law Institute, which is located in New Delhi, right opposite to Supreme Court. So ILI format is the Indian perspective of the same itself. So always use a common method. There are others which is used in social sciences as well, like the APA format, the Chicago style of citation, and so on and so forth. Ensuring accurate and complete citation. Okay, what does this citation do? These citations help you to locate a particular reference that you have drawn out in your particular research paper that you have written on to. And finally, once these two steps are completed, and you can see I've followed it with an arrow. With an arrow, which means that first this needs to be done, second this needs to be done, and finally we'll come to the third aspect of it, that is the proofreading and editing. So this is just like the final this is just the when everything, my pizza is ready, I'll just add a few of the peppers, shape it in that particular way, cut it into the perfect of these slices, and present it with the best form of decorative way I can do that. Because unless it is presented well, it won't be liked at all. So please review for grammar, for spelling, for punctuations, and seek, this is very important, seek feedback from your peers or for your instructors as well. I don't know how many of you are very active on your LinkedIn. If you are, I personally believe I'm not using any other social media, no Insta, no Snap, no Facebook. I am only active on my LinkedIn. And believe me, when you frame your own profile there, get into the habit, any one domain which you have sought for your own self. It can be arbitration, it can be, if it's an IPR, that's something that I generally am very inclined to. Have an habit of locating which law firm partners are you following, which law firms are you following. For example, for IPR, Anand and Anand is one of the leading IPR law firms that we see. Other sides, M&A, you can find SAM, CAM, AZB, Luthra and Luthra, Khetan, and all those. Now, when I'm talking about these particular things, have this habit to start off with your own blogs. That is the best way that you can enhance your legal skills, specifically when it comes to the researching part of it. Now, before I move out there, this slide is the utmost slide that I'll not only urge, but also request each one of you here. And that is plagiarism, confidentiality, and competency. This nowadays is the most integral part of it. Please understand and avoid plagiarism by properly citing. And this is again, I'll come back. The citation format is still important. When you cite certain thing in a legal domain, that I've read this from an article written by Mr. Parth. Please do acknowledge it that this particular portion I have taken, put an Control-Alt-F on a Word file that automatically adds to your footnotes, and then you start doing it. This, number one, enhances. Like when I'll get a research paper written by Navya, and it already has mentioned with the proper citations of various other authors, I would see this, that during the course of writing of her finalizing of her research paper, Navya did studied on that topic of the renowned authors. So that automatically, for me, as a person who is reading a research paper, would make it a point, okay, she has read the good authors on the same, the authorities on a particular topic. She has mentioned that in her paper. So she is giving due consideration to their fact. And again, even if you disagree with their positions, do mention that provision, what they said, make it a proper citation in the footnotes, and then under the next paragraph, that this was the point, but I disagreed because of this logical reasoning that I'm giving on. This would enhance your particular research that you have done on. Second and very important concept again comes is in relation to confidentiality. Before I move to confidentiality, today the only check that we get is in through the forms of softwares like Turnitin, Drillbit, Urkund, which not only helps me to check whether this paper is being a copied paper, but nowadays with an enhanced version of it, it also helps me to understand that whether the AI content in your research is there or not. Avoid shortcuts. Research is not about shortcut. Research is only and only how well you dive into that deep sea of research. And that is again where I started. I still believe myself that I'm on a very starting stage of a legal research, and I call myself to still a legal research scholar, in spite of having done my PhDs and everything. These are just the degrees. The way the law is being developed, the way the new things are being coming, I can never claim this particular tag that I'm the best legal researcher available. But yes, the tools and techniques that I'll start using to write on that particular point, that will make me, because if I'm reading good research scholars on the same, the authorities on the same topic, and then analyzing my research over the same, I would be in a very different situation to take it up. Finally, the competency. Conduct thorough and competent research, acknowledging the limitation of your expertise. Now, no PhD thesis, and I'm coming to the final version of it, that forget about research papers. Never consider that what you are doing a research is the final research, and after this, there wouldn't be any research on the same. I'll tell you why. No research can be considered. So always determine that these are the limitations of my research. And I'll tell you why. A good research, when it defines the limitation, it serves two purposes. Number one, it encircles your particular domain कि only you did it for this particular portion. बाकी की चीजों से you are not aligned to it. Number one. Number two, further researches on your limitation, जिसको हम research gap बोलते हैं, is always open for others. अच्छा, इस टॉपिक पे ये रिसर्च हो गया, लेकिन इनके रिसर्च पेपर पढ़ने के बाद I came to know this ambit and this ambit was not covered in the research done by Navya. So Devanshu gets a hint. Okay, ये तीन टॉपिक पे, इस मेजर टॉपिक पे तो she has already done. ये तीन टॉपिक उसने छोड़ा हुआ है. So this is a hint from Navya to Devanshu, and this I can only get if I have read Navya's paper on the same. सो वो तीन चीज मेरे लिए एक हिंट है फ्रॉम नव्या कि देवांशु यू कैन टेक ईदर ऑफ इट एज योर रिसर्च टॉपिक टू further this particular research. And when I'm doing that, I need to properly cite Navya's paper because I read that particular paper. This is called as a thorough and a competent research, and please acknowledge the limitations of your own research as well. So coming nowadays, which is much more helpful for us, the online research tools and techniques that we can take on to. First, the legal databases, as I mentioned in my previous slide as well, Westlaw, LexisNexis, Hain Online. They offer free trials. There are student subscriptions. There are advanced search. Major of the law schools in the country have the subscription of these. Google Scholar is second, where I'll say, please make your profile today on the Google Scholar as well. This is not particularly limited to the legal thing, but does have the other things. Here comes another important thing which I was trying to let you know. Justia, Find Law, Cornell's University Law School, they provides free access to the statutes. In India, we have something called as indiacode.nic.in, where all the legal acts, ordinances, and all these things are available, both state-wise and the central level-wise as well. There are free online libraries as well that gives you access. If not, I'd also request, and this worked for me when I was pursuing my PhD as well. I randomly went to the law school libraries. So when I was working for my PhD in Bhopal, I even went to NLS Bangalore library. I even went to Nalsar's library. I came to Delhi. I accessed the ILI library. I accessed the ISIL library, which is both are adjacent to each other. I went to NLU Delhi, and just one letter addressing the librarian of a different law school, free of cost, you can access the library of the other law schools. Nowadays, there are certain good legal databases which are like LII of India, if you can type that. LII is basically the information that is being given onto. LII is there for many countries, but if you can search LII of India, that is one thing which I'm requesting once again. It's free of cost for all of you. Wherever you are sitting, in your home, in your hostel, wherever, you can access major of the legal databases. So this allows also a request. Please, in spite of asking that to your own university, if it is there, wonderful, well. If it isn't, please have this habit that you want a legal database for your library access. And nowadays, major of the databases are providing an IP access with 3 or 4 remote accesses. So have this habit to demand it from your university that you want a legal database for your own particular thing. I know there might be one, they might not agree for the second, but have this habit of peer establishments as well. So I can request Navya to, and I do not know Navya and Sweksha are from the same institute or not, but I can speak for Fennel. I know Fennel is from GD Goenka. So you can have, okay, Fennel, you at your university has Westlaw and Hain Online. Uh, Now we have Westlaw and LexisNexis both. So one is covered by Fennel. With a common database, somebody at a different law school can have many law schools, the national law school, they have all. So that is something that you can take it up. And if it is there, you can divide that among you, or you can have a peer opinion. I guess that's a wonderful work done by Legal Lock team when they have created a WhatsApp group for you people. Please utilize this. This is not a WhatsApp group only for this chapter 1. Please have this and utilize this option where they have taken that step where students from various other law schools of the country are coming together. You can access notes of each other, you can access your own writings, you can jointly write papers, you can jointly go and like these peer helps, or you can exchange your papers. That Fennel can send a paper to Navya. Navya, I have written on this particular topic, can you please give me your inputs? This exercise of your peers, that's where LinkedIn comes into play, where you can utilize experts from various panels that you can take it up, can you please check, and other things to be taken on to. So with this, I'll take a pause. I have mentioned my email ID out there. You can feel free to write me for any legal research thing that you have and help out to. I'll generally reply on emails within 48 hours. And I will love to, it's not like I will only help Fennel because he's my student. No, if it is a law student and they require any help regarding legal research, I guess Legal Lock team can also vouch for that. I'll be readily available to do that. So with this, thank you so much. And I'll again end my line from where I started. Good readings would always help you for good writings, and keep that researcher, keep that researching skill inside you active. So even if you're writing an answer to that on a mid-semester, in your mid-semesters, to writing for a research paper being published in Scopus journals, please have that habit of doing that thing clearly. So Iksha, you are asking me how to start a research paper. I would come back to my slide 1. So I hope you have had my email ID there. If not, I'll share this PPT with them. This is how the IREC method would help you. So Swiksha, whenever like I'll tell you, you'll have to take a topic, being unbiased. So don't say कि नहीं मेरे को ना reservation हटाना है, मेरे को ये topic चाहिए. नहीं. Why you are going to take this up is an answer. Again, Navya, there is no standard formula of having a wonderful topic. Why? What might sound wonderful for Navya might not be wonderful for Swiksha, Fenil, or Devanshu. And as I said, don't go by a formula that this is a wonderful topic according to me, because you are writing it for the world at large. उनके लिए वो wonderful हो ना हो. So don't go for that thing. But keep it as simple that the title, like for example, if I just say, Navya, please on your mic. You know that in the entire of this gathering, I'm only asking Navya to on it. Similarly, when you are framing a title or when you are taking a research paper ka title, number one, keep it plain and simple. Ki kal ko if Devanshu has to read something on a particular topic, I can ask Navya ki Navya ये वाला टॉपिक जो तुमने लिखा था वो बहुत अच्छा था और तुम्हारे टाइटल से मुझे समझ में आ गया कि मेरे को क्या है, तुम्हारे पेपर में क्या है. तो as there is a your name that symbolizes कि अगर भीड़ में भी कोई चल रहा है, and if I'm calling Navya, Navya would turn back and see it to me. Your research paper title should also reflect the same, that somebody who's seeing that should be clearly able to understand that अच्छा ये पेपर में ये लिखा हुआ है. Number one. Number two, okay, I'll come to that point. Sorry. I hope my mail ID is visible now. I'll keep this slide open, no worries. Number two, I guess I was coming back to Swiksha's question, ki how to start a research paper. I'll first say you require an intent to be a researcher, then only you can start off with. It can be, always start slow. Always start off your own comfort zone. I'll say that as well. Like, for example, I do not know, and Swiksha, if you can just switch on, I request everybody, they can on your mics, if not the cameras. Like, for example, Swiksha, if I'm asking you what, like, which year you are, if you can just quickly introduce yourself.
From Mumbai University, 5-year LLB, first year, first semester.
Okay, so you have first semester, okay, you recently started in 2024. What do you want to become, Swiksha, 5 years down the line?
Judiciary.
Perfect. महाराष्ट्र ट्राई कर रहे हो कि कहाँ?
DJS.
Delhi. ठीक. Now for you, if I have to ask you to write a research paper, number one, how many subjects are there in Delhi Judicial Services?
I think it's 4 to 5 right now.
There are 13 subjects.
Okay, you asked for subjects. Sorry, I told sections.
There are 13 subjects as in present. Abhi, you have started very early. So I'll tell you, you can only be eligible for writing a DJS ka paper would be in 2029. Okay? Now, you have to clearly demarcate yourself. DJS के ये तेरा पेपर है, ये वाला मैं फर्स्ट ईयर में पढ़ूंगी, ये वाला सेकंड ईयर में पढ़ रही हूँ, ये वाला थर्ड ईयर में पढ़ रही हूँ, ये वाला फोर्थ ईयर में पढ़ूंगी और ये वाला हो सकता है मैं फाइनल ईयर में पढ़ूँ. Analyze yourself with that particular point. So for example, if you're studying contract, which is one of an important component for DJS, your legal research should be, okay, I've read consideration ye hota hai. Okay? I hope everybody knows what consideration is.
Yes.
Okay. You have studied contract, na?
Right. For law entrances.
Okay, not in your first year, Abhi?
In second semester, it will be.
Okay, in second semester it would be. But all those who have studied, so there is the toughest definition in the entire section 2 of the Indian Contract Act of 1872, which is 2D of consideration, and which reads, when at the desire of the promisor, promisee or any other person has done or abstained from doing, does or abstains from doing, or promises to do or abstains from doing, such an act, abstinence, or promise is said to form the consideration to the agreement. This definition I learned in 2007. The point is not that I'm trying to showcase my talent out here. No, I never learned that definition. This was my presentation topic. I never learned that definition. And I'll always cite this example. Half of us, this is again what I've seen, and it can be of anything, no religious connotation to that. But there is something that is something called as a Hanuman Chalisa. I do not know how many of you know what Hanuman Chalisa is, or whether you have remember the entire thing or not. But you never take a book and just read, नहीं 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 आज खाना तभी खाएंगे जब मुझे हनुमान चालीसा याद हो जाएगी. No. 7 days together you read it from the book. Believe me, 8th day you will not require the book. Now, if today I have to write the essential ingredients of consideration, I'll say it requires 2%, promisee or any other person. It has to be at the desire of the person, and then it consists of past, present, and future. And in the entire definition of consideration, there is nothing mentioned about amount, paisa, which explains that consideration can even be of kind. You remember barter system? आप मुझे 1 किलो आलू दो, मैं आपको 1 किलो प्याज दे दूंगा. So this was also a valid contract because the consideration was a legal consideration. And 2D cannot be read alone unless you are not reading section 25. And section 25 reads, an agreement without consideration is void. So what I'm trying to let you know that if your ultimate aim is judiciary, please focus on those 13 subjects which are there. And that will help you to not only deep dive into the particular subject knowledge, but also to understand, and you're preparing yourself. It's not like, Sweksha, that you will prepare yourself for the judiciary exams in 2028 or 29, 4th year or 5th year. No. Have that thing that you will be preparing yourself from the first years. This would help. एक साथ 13 सब्जेक्ट पढ़ना और एक साथ में पहले सब्जेक्ट एक करके. This is again a way. Now the pizza that I prepared, you remember in the example, is ready for you to eat. How do you eat a pizza? You'll take one piece, take a bite at a time. And then you have the capacity to finish off the entire pizza. No denial of that. But then also you'll take a piece at a time, a bite at a time. And this exactly is how you divide. This exactly how you would research on that particular topic. And for you, the research would be something else. You need to see, okay, past year में अभी मेरा second semester में contract खत्म हो जाएगा. Let me see past 10 साल में DJS में contract के क्या क्या सवाल आए. और क्योंकि मैं contract पढ़ चुकी हूँ, am I able to answer these contract questions? Don't go for CPC, don't go for CRPC, don't go for TPA, nothing. Just see the contract thing and how much are you ready with that level. So for you to identify a good legal research, you need to be very clear what is your area first, and then how you are dividing that particular topic into various other things as well. I hope I have answered that thing.
Yes, sir.
Yeah. I've also answered how to find a wonderful topic. Email ID is right there on your screen. I hope it is visible for everyone. And there is the attendance link by Parth. Any other questions to anyone? Silence amounts to acceptance. So thank you so much, Parth. Thank you so much, Varun, for inviting me. I'm just closing the slide now so that I can see each one of you.
Thank you so much, sir, for this amazing session, and first of all, for accepting our this offer to be here and just enlighten all of us with the basics and the core process of how to write a research paper. And I'm sure that all the ones who have attended this, who have actively attended this, would surely be coming up to you for more suggestions because you have already provided your email ID. And we would also love that if you connect with us also, and sir also, if in any case required for your research or any guidance if it is.
Yeah.
I'm glad that while discussing about the resources, sir mentioned about Heen Online, and I mean I feel it very happy and I feel pleased to share that Legal Logs, one of the core journal, that is the Legal Log journal, is indexed with Heen Online and is available to you and is being read by multiple and thousands of students from different colleges all over the nation. Alongside this, sir also mentioned about various other legal resources, that is LexisNexis and so on. So I will take this platform as an opportunity to introduce or to give you a glimpse of what is the future of legal law. And I'm sure that on the 1st of January itself, we'll be launching our first look or the revamped look of the legal law. And I'm sure that it will be helpful, because now, because earlier our major motto of legal law was making law simple, but now it will be revamped to convenient and comfortable learning for every law student. And you'll see it like from 1st of January itself, you'll see this change in legal law, in the ideology, in the process, in the events, and everything will come up forward in 2025, or say from 2025. Now, I'll request Varun Agarwal to just announce the offer that he mentioned in the opening. And now, Varun.
Yeah, before jumping to the offer part, I really want to thank Devanshu sir for being here, for spending out time from his busy schedule. Moreover, sir, if it's possible for you, can you please share your LinkedIn profile in the chat box so that
I'll
students who are willing to connect can do that?
Yeah, I'll do that, Varun. And before, I guess you announced something which I guess everybody's waiting for. So I guess, Parth, it's good time for you to change the name of legal law to legal unlock. The way that you have described and how you are unlocking the particular perspectives of legal law. Brilliant, and kudos to the entire team. And I know these two guys. They have been wonderful. They have been a great thing when it comes to providing a platform. He rightly mentioned about his own journal and the fact that's there. So please take it and utilize these options, guys. I'll be very honest again, and I said during my presentation as well. When I was a law student, we were not getting such platforms, and today I really regret as well their point. Okay, if we were given these platforms at that particular time, I guess the scenario would have been something different. But it's never too late to start off anything. So kudos to the entire team of Legal Lock. And that was just a joke of legal unlocking that. But the log that you people are, believe me when I say, when you are unlocking those the levels of legal research, by all means, not only by creating awareness by these sessions with your chapter one. I am really excited. If and please count me in as an integral part of yours. I
For
would
sure,
love
sir.
to be there and support you people for anything and everything under this wonderful ambit of legal law you people are doing. So more power to you guys. And Varun, I'll not take much of your time. I'll use, by the time you announce it, I'll post my LinkedIn profile to the chat box itself.
Thank you, sir. Thank you so much. And now, guys, since I think most of the things have already been told by Par, that the first thing which we was about to announce is the upcoming new portal, and the legal log, as sir said, needs to be unlocked, and thereby the legal log is going to be the lock portal for you all. And with the motive that once you come in, need not to go out, you guys will get everything you need. And stay tuned, stay connected with the legal log for that. Surely by the end of the first quarter, you'll get a full-fledged thing available online, and by the 1st January, as Parth stated, you can see the new things happening and new things coming in. And just to tell you what the offer was, since you guys have been a great audience for 3 days, and first of all, we are really sorry if we have caused any inconvenience to you, and secondly, thank you so much for adjusting where and where it's required. We know that none of our session was particular by the time. Someone was 2 hours, some was 1.5 hours, someone 1 hour 15 minutes. But we hope that we have given you a lot of values. We hope our speakers have justified for whatever they have chosen. And with that, I really wish to announce that we have a course that is a 3-week PDF course for mooting, which you guys will get it absolutely free. Its MRP is 900, but since you have been a great audience, so me and Parth has a discussion that there is no point of giving you a discount. It's definite for you to give it for free. So on that note, we will give you free. Just a small request from your end. We would appreciate if you guys can give us a feedback on LinkedIn. Just tag Parth, me, and the legal log, and we'll circulate a Google form. Just upload a screenshot that you have put it in on LinkedIn, and for within 24 hours, you will get the moot court kit. This offer is valid for next 2 days. So please free to post within next 2 days and get this offer. As soon as you post, fill in the form, you guys will get the whole PDF course with you, absolutely free, no charges. Thank you so much for being a great audience. Thank you so much, Devanshu sir, once again. And if you may please want to add something, then nothing can do better than that.
No, I guess that is a wonderful option and a wonderful gesture in the entire team of Legal Law for extending that. It's not merely a money minting thing that for you people, which I've always been appreciating of. So if this were, I know the audience, and I'll really thoroughly enjoyed with the number of questions that we've been posing on to. So thank you so much, and wishing you guys all the very best. And I'm happy new year to all of you. May the year 2025 bring all the happiness and good health for you all. So on that note, thank you so much once again for inviting me, and count me in whenever and wherever, whatever you people need on to, in all the capacity as I can and I may. I am with legal lock, so lock me inside the legal thing that you people are prepared for. So thank you so
Thank
much.
you so much, sir.
Yeah.
You can just
Thank you
unlock
so much,
that
sir.
offer, Sweksha, by posting it on LinkedIn. Just put it the post in the Google form which we will circulate, and you have unlocked it. I think we just got a new term, unlocking the lock, and I'm pretty sure Part's gonna use it in the
I know that.
PR
I
video.
am pretty confident he's going to use it.
Pretty sure Part has
I
got
wish I
some
could
things.
also join this particular course, but there is no mooting thing for the teachers available right now. But no,
But sir, I think we will definitely wish to have you as a judge in our upcoming fourth national moot court competition,
that
and I
goes.
think
That
that
I
will
guess
be a
Parth is already booked me for that. So that is something that I've already agreed to. No, that's something
yes.
that we can take on to. Even I'll tell you, when I was a law student and I was more into mootings and then taking it up. So that's again one of the things. Until unless the audience is not getting bored to listen to me, I would be love to like share whatever things that, because nowadays I'll tell you um, I'm judging majors of the moot courts, both nationally and internationally. And believe me, as a judge, when we see, because there is certain thing called as a score sheet which we evaluate the young students. So I and believe me, when I was mooting, I wish I would have known this structure, what all points will be judged on. There are few like 7 or 8 sub verticals under which the judging and the parameters have been taken onto. Nowadays, even we have an arbitration tournaments or a mediation or negotiation tournament at different level. And if Parth and Varun may allow, for the moot, I guess Legal Lock is coming with one of the moot court competitions. Alongside that, we at GD Goenka, we are also organizing the 7th edition of the SIAB International Arbitration Moot Court Competition. Being in its 7th thing, the last date for the registrations is still there. Anyone who wishes to, just, you have my email ID, you can connect me over the LinkedIn. We will help you to like invite you or your institution for that matter to be a participant in the same itself. I guess Fennel is there. Fennel, if you can just share the details on the group, I guess that would be a great thing for all the participants as well.
So they all are in the like different groups, but we have a common
Okay.
ideology. So we can mail them everything. So
Okay.
I think
So
Fadil can help us.
yeah, if that's there, I would request Fennel to forward it to Parth, and then Parth or Varun, either of you can put that thing.
Yes. Yeah.
So with the
Fine,
form
guys.
that we'll be sharing for this particular thing, the LinkedIn post, will share you the details of this particular competition also. So that if you are willing to be a part of it, then you can surely like join it.
Okay, so Sweksha, I guess first year is too early, but I would suggest if you really are inclined towards moot court, I would say start with debating, start with NUN, start with essay writing. These things would definitely not only boost your own confidence, but by the time you are there, that would enhance, and even in your own institution, this would help you. Okay, you have done this, you have done this, and your CV would also get stronger for that. So by the time you enter your second and third years, whatever may be the rule at your university, but at this moment it would be too early because major of the laws of the country that you have not studied, and moot do involves your procedural and substantive law together. So that is how you'll be taking it.
I'll just be adding one more thing. Thank you so much, sir, for this guidance to Switch also. But I must say that the moot court that legal law presents means I mean now we are getting into a conversation here. But the thing is that the mood that legal law brings is usually centered for freshers only, because there is something that every college has a committee, and every student has to pass this particular test of being number one or number two to get into other competitions. So legal log actually brings up this opportunity, as we also invite independent participations, that if you're willing to learn, if you're willing to just take a test of yourself, that if you are okay with this or not, or how it is evaluated or how it is done, then I guess legal locks moot will be the best option for you guys, because there is something we invite independent participation, and we have teams, we have judges from all around the nation, and uh, they'll be guiding you all through the way. With every mooting round, they'll be guiding you, they'll be giving you feedbacks, and that will surely be helping you in like participating future competitions. Uh, so yes, with this, uh, I'll thank all the participants to be a part for these 3 days, and I wish that you all would have enjoyed it. I again would like to thank Deevanshu sir uh, taking out time and teaching you all the core and about research writing, and all the other details that have been discussed in this particular session will be communicated via mail to you like in a few hours itself, so you need not to wait for that also. But yes, for the feedbacks, we'll surely like you to mention all the mentors also, Devanshu sir, Bobla ma'am, and Achintya Anupam sir.
No,
So
sorry, not Achintya. No, sorry. I have to interrupt him here. Don't
okay,
mention Achintya Anupam. That's not allowed by Khaitan. So please, don't mention Achintya Anupam. I repeat.
yeah. Don't mention it. So yes, do
No,
mention your
don't
mentors
mention
who all you want you can. So thank you so much. With this, we conclude our benchmark chapter one. We have been an
it.
amazing people there. Thank you so much, sir. Thank you.
Yeah.
Thank you.
Thank you.
And
And I'll
just to
share my
put
PPT with Parth
yes,
and Varun. And if the students get benefit for the same, I guess you can circulate the same to them as well.
For sure,
yes,
sir. With the
definitely.
else itself, we'll share everything
Yeah.
that is
So
required to be done.
the last slide has the email. You can send it to them. So it's absolutely fine if they want it. But any of the slide they want to, that can be of their any help to them. I guess I'm happy to share it.
And just to
Yes.
put a cherry on the cake, as we were discussing about moot courts, for the last moot court session, we for a judging, we had Honorable Justice Gopal Vyasar, who was former Rajasthan High Court judge. We had hosted Honorable Justice Vineet Kothari, who was former Chief Justice of Gujarat High Court. We have Honorable Justice P. Nagaraman from Telangana High Court. So though it's an open moot, we don't personally ask for college authorization. That is just for the students' benefit. We don't compromise with the bench. If you participate, you're gonna go in front of the actual judges. Good bench, not affirming that every time you will have a judge, but definitely you will have a best judge, that is bench that can be possible from our end. So that was it from our side, and thank you so much, everyone. I wish to call it the benchmark chapter one closed, and stay tuned for chapter two.